Hey, everybody. How are you tonight? Um, Jen is traveling, so I'm going to be on my own this evening. So just wanted to let you know, please be gentle with me because I'm doing it all myself. So thanks for joining me tonight. As usual, it is True Crime Wednesday. I'm Lori Hellis, a retired criminal attorney, author of the book Children of Darkness and Light. Hope you all had a wonderful Mother's Day. These beautiful flowers, I always seem to point the wrong way. These beautiful flowers were a gift from my daughter for Mother's Day, and we had a really nice brunch. My son-in-law's parents were in town, so we had Mother's Day with them, which was delightful. And so I just wanted to say I hope you had a great day as well. Um, Hello, Liz and Jackie and PJ, and welcome. Thanks for joining us tonight. We have a few things to talk about. First of all, I wanted to talk about Lori Vallow. She had kind of a spicy pretrial for her next trial coming up. And I thought it was really worth playing a few little excerpts of it. So let me just share my screen and we'll get to that. So I don't know whether I can make that larger or not, but you'll get the gist. Let me know if for some reason you cannot hear this. So these are just a few little bits from the hearing that she had today.
All right, then we have the defendant's motion for no restraints in trial dated May 6th. I don't know, in your motion, I don't know where you get the idea that the sheriff's office recommendation ever was that you have no restraints at all.
This judge has been so patient with her, and she's paying him back in spades.
Minimum recommendation was that you wear a
Because we all know that no good deed goes unpunished. So here's her response.
rack belt.
Well, I have it right here and I copied it verbatim.
Yeah, you
Okay,
said, what it said was my recommended minimum requirements as listed above, and those were to wear a rack belt.
It said, or the recommendation of MCSO was that they could have a unarmed detention officer and an armed deputy sheriff if I was to not have any restraints.
Right, but that wasn't their recommendation. I've received the defendant's motion. I've received non-party Maricopa County Sheriff Jerry Sheridan's response.
On the MCSO security justifications, my understanding is that was his recommendation.
Your Honor, Joseph Vigil for the Sheriff's Office, if you have any questions.
Oh, okay. Well, I'll deny the motion from the defendant. The same conditions will be set that we had in the first trial, that being you wear the rack belt, no leg brace. There was one incident during the trial where you asked to take a break because a strap was hanging down behind your jacket.
Mm-hmm.
We did that. We rectified the situation. There's been no indication whatsoever that the jury noticed the rack belt or anything like that. So I think those conditions are appropriate and will remain for the second trial.
Your Honor, the jury was not polled to see if they noticed anything either. Was that correct?
Right. There was no request for that. All right. So next we have.
So you can see her look over her shoulder. I don't know who she's looking at, but it's very clear that she's not happy about this ruling, that she's angry that she's not getting what she wants. And that just continues when we get here. Trina Kay is frustrated that Lori has put people on her witness list that Trina Kay has never heard of and that she's having to Google. So
I'm going to ask her about the other
Okay.
witnesses. I received your supplemental witness list, I think yesterday. You have, in addition to Mr. Dorkin, you have Weaver, Barkman, again, Detective Moffett, Jeffrey White, Melanie Gibb, and Zulema Pastanas.
Zulema Pastenas.
Okay.
Mhm.
Was Detective Moffett also involved in this case?
He was involved with the case agent of this case while he was the case agent of the other case, correct?
Okay. So he may or may not have, he may have relevant information. Again, I guess that's a wait and see. What about, who's Weaver Barkman?
So he's a ballistics expert.
Is that an expert? So that's an expert. Do you have an expert report that's been disclosed?
So here's the thing about experts. Experts have to be disclosed, including their reports, far in advance of trial. There's a reason for that. Because the other side then has the right to have their own expert examine your expert's findings and report. So apparently she now has a ballistics expert, but nothing has been disclosed to the state. And they are way beyond the deadlines for expert witnesses to be disclosed. Now, in the last trial, she complained she wanted Lonnie Dworkin, who is a cell phone expert. And in the last trial, she complained that they had requested funds from the state for her expert in January, but it hadn't gotten approved until just 2 weeks before trial. The judge ultimately did not allow her to bring in her expert's information because it was so long overdue and was so far past any of the discovery deadlines. So that's what she's up against yet again, this time with a ballistics expert.
Not yet, Your Honor. We're working on it.
Your Honor, since I have not noticed a ballistics expert, that's a big problem because if I get something, then I would have to do that. So the defendant's, again, extremely late, violation of all rules of criminal procedure.
So what Trina Kay is saying is that she doesn't have a ballistics expert on her witness list. So it's not as if Lori is calling someone to refute what the state is going to put on. She's actually looking for a ballistics expert that's going to give the court new information. It's not that she's going to be refuting the state's evidence.
Is a problem.
It is a problem. Who's Jeffrey White?
My investigator.
Oh, okay. And do you have an idea of in what capacity you think he would be called?
Well, we had made a request from the state for the car door and the window that the bullet supposedly hit, and we were going to have him inspect that as well. We have recently found out that those two things do not exist. So
Probably because Brandon Boudreau had his car fixed. It hasn't been sitting without a window and with a bullet hole in it for 5 years, waiting for this to go to trial. So, and it may very well be that Brandon Boudreau doesn't even have that car anymore. So she's going to have to rely on the photographs and the information that was gathered at the time of the incident, which she's not happy about. So
I'm not sure what they're going to be putting up as far as ballistics in their case in chief. So I was trying to have someone who could be able to look at whatever reports they're trying to put up and rebut anything that they're saying.
Is Mr. White an expert in that area?
Mr. Weaver?
No, I said Jeffrey White.
He's my investigator.
Right, that's who I was asking, who has relevant information. what's Mr. White's relevant information for why might he be called as into trial?
Because he's interviewing the witnesses as well, the defense witnesses.
So is it some sort of extrinsic impeachment if they?
Correct.
Lori has absolutely no idea what extrinsic impeachment is, but she figured out that if it had the word impeachment connected to it, that would be enough. What he's asking is the only reason that Jeff White, who was her investigator and who interviewed some of the witnesses, would come in as a witness would be if the witness was now telling a different story on the stand than they told Jeffrey White. So that's what the judge was asking.
What about Melanie Gibb?
So Melanie Gibb and Zelina Pastinas were both initially noticed in the state's 15.1. They have not noticed them again. I don't know if they can still call them if they're on their list, but they have relevant information to this case.
Have they been presented for an interview by the state?
They've both been interviewed multiple times by the state.
I mean, not by police officers. I mean, by either a prosecutor or someone in her office or in preparation for trial.
In this case?
Yeah, in either case.
Not that I'm aware of.
Have they been subpoenaed?
The subpoenas are out.
What relevant information would they have?
They have relevant information to Brandon Boudreaux.
Okay.
And around that
What
time.
is the nature of that relevant information?
It will come apparent if they have to get up and testify, Your Honor. I will only call them if I need
They're going to
them.
be precluded if you can't give me some minimal what relevant information. Just saying that they're relevant doesn't make them relevant. Okay?
Yes, and there's this procedure that I have to say what each of my witnesses are relevant ahead of time and give my whole case in chief over to the state. It is?
Yeah.
That's how it works? That's the rules of law?
Stop interrupting me. Yes. That is the rule of law. That's just what.
Yes, that is exactly the rule. In criminal law, you have to be absolutely transparent and turn everything over. She doesn't want to do that because she wants to be able to ambush the state, and that is exactly what she can't do. So I have to say, I thought this was a little amusing, and she definitely was a little hot under the collar over it.
What the state does. They tell you what relevant information each witness has. So my answer is yes. So if you can't tell me what relevant information they have, they'll be precluded.
They both have had dealings with Brandon Boudreaux and Alex Cox. So
okay, so does someone that was a server for them at a restaurant. It doesn't make them have relevant information as to this case. Anyone who came into contact with Mr. Boudreaux or Mr. Cox had some interaction with them at some point in their lifetime does not make them a relevant witness. So what is their relevance?
the state had them on their witness list and they're saying they're not relevant?
Apparently not. Are you calling them?
No, they're not
Right.
on my,
Police interview however many people they interview because they're working on the case. They don't know who has relevant information, who doesn't have relevant information. All the people that they interview don't end up being relevant. So because they're listed in a police report somewhere, doesn't necessarily make them relevant.
Okay, their relevance lies in if I have to rebut something that the state puts on in their case in chief. They're just called in case they need them. They're subpoenaed in case I need them.
All right. It sounds like they don't have relevant information. However, I'll include these names on the potential witness list for screening the jurors if the jurors have any knowledge of any of these witnesses out of an abundance of caution. That's really the purposes for today is the questionnaire that goes out to the jurors. So I will include these witnesses. Again, Mr. Dworkin, Mr. Barkman, if they're expert witnesses that haven't provided any sort of report or expert witness testimony, they're likely to be precluded as witnesses, but I'll include them on the witness list. I think what I'm hearing is you said you might finish on the 9th or the 10th?
So now the judge gets in a bit to scheduling and how soon the case might finish. So, but we will get into the last little dust up because that one, well, the last one is really the juicy one. I saw this comment. I do have a new microphone on my headset here, and I'm glad that that the sound is better. So I appreciate that feedback. It's important for me to hear these things. So if the sound is good or the sound is bad, it's great that you let me know that, and I appreciate it. So yeah, let's get on to the next little juicy tidbit here.
Your Honor, in light of the juror misconduct or the alleged juror misconduct.
So the judge is talking about the juror questionnaire that goes out to potential jurors when they're summoned. And first of all, she says, in light of the juror misconduct or alleged misconduct, and the state has been very clear. They've filed a response to Lori's accusations that there was juror misconduct, and it's very clear that there wasn't, that this juror only found out that Lori had been convicted after the trial was over, the guilty verdict had been rendered, and somebody in the hallway said, "Hey, you ought to Google this woman and find out about her." So it's clear from the information that's been provided by the state that that's what happened. But Lori is absolutely grasping at straws to find some reason to get a new trial or to have her conviction thrown out. And she's not doing a great job of lawyering, and it gets even worse in the next little blip. But let's listen to this
I
one.
have to object to us having so much information go out about my personal information in that jury questionnaire. Do you not think that was a problem?
What personal information?
The state versus Lori Daybell.
What's the name of the case?
Yeah, but you don't put that on anyone else's questionnaire, or one other person that's ever had that questionnaire ever put out with their name on it. They just don't do it.
Do it in every trial I've done.
Then the people are just going to Google it, and then we're going to have the same exact problem we had getting a jury for that case. We're going to have the same exact problem.
Are you done? Are you just going to keep? Okay. How do we screen for?
Judges do not like people who talk over the top of them. It is simply not done. And Lori just does not really understand courtroom decorum. And as usual, Lori is always doesn't count for me. So even if she understood courtroom decorum and the rules, it wouldn't count for her anyway. She's going to do it her own way. So
or if people have heard about you, if we don't include your name.
I love this long pause. She doesn't have an answer.
Do you have a response to that?
I'm just saying, you gave them the name and they're just going to Google it.
They're instructed not to Google it. All right. And if you'll recall, when we had all the jurors come in person, one of the first questions I asked them in the afternoon was, who has looked up this case since you filled out the questionnaire? And we had 2 or 3 people raise their hand, and those people were excused. So I have to include your name to screen out for the people that know about your case. And we released about 100 jurors last time because of their answers to that. If we don't include your name, that's 100 extra jurors we have to go through in person and ask if they know you. And in fact, that increases the risk of tainting the rest of the jury pool. If we have someone stand up and say, yeah, I know about her case in Idaho where blah, 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 in front of the rest of the jurors, that'll burn the whole panel. We'll have to start over. So I'm going to include your name in the questionnaire. I don't think there was any other personal information or background information about you in that questionnaire other than your name. So was there any other issues you had with the questionnaire?
No, Your Honor.
Ooh, you can just hear the she's seething. You can just hear it in her voice. And several times she turns back around and looks over her shoulder. And boy, if looks could kill. So now we get to the particularly gnarly and juicy part of this.
You would recuse yourself from the obvious personal bias.
Sorry.
And then we'll plan on going Monday through Thursday, June 2nd to June 5th, then June 9th to June 13th, and if need be, June 23rd.
Your Honor,
Yes.
I have to ask that you would recuse yourself from the obvious personal bias that you have against me and send us to master calendar for this scheduling of a trial.
And what personal bias is that?
A lot, obviously, the personal bias that you're showing right now and that you've shown on the FTR several times during the trial.
Okay, well, I don't have any personal bias, all right? I've over accommodated you on when you have to disclose things. In fact, your expert should be summarily precluded today, and I haven't done that. All right? So
You denied every single one of my motions since for a year and a half that I've been here. Every single one of my motions has been denied. And have any of those motions not have merit? You've denied every single motion.
I think I was here this morning about 15 minutes ago when I granted your motion to meet with your attorneys over the lunch hour. I have granted other motions of yours. Okay,
That's the first motion that you've ever granted
well,
in my behalf.
file motions that have a legal basis and I might grant them.
So you're saying none of my motions have had merit.
Not many, no.
And none of the motions that my first team, you denied every one of my first team's motions. You denied every one of my second team's motions. And now you denied every one of my motions until today.
I haven't denied every one of your motions.
Every single one of their motions was denied. Every single one of the second team's motions were denied, and all mine. So you didn't come into this with any bias against me in the first place?
Again, file a motion that has legal merit, okay?
And none of my attorneys ever filed a motion with any legal merit?
They filed a motion on your behalf, the first team, to preclude media coverage, and I issued my ruling according to the law, all right? They filed a motion to have you dressed out, not in jail clothes during hearings like this, okay? That was not based in law. I denied that motion. So I've ruled on the motions as required by law.
Without any kind of a conclusion of law in them, just denied, 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 denied. Does that not show a bias and a prejudice against one single person?
All right, are you done?
Are you not going to recuse yourself?
No, I'm denying your motion. Anything else? All right, I was handed.
Oh boy, was she mad. And he was so calm and so even-handed. So I had to give him credit because I think I would have been a little more hot under the collar. But then that's why I never wanted to be a judge. Don't have the temperament for it. So they go on to talk about new motions that have been filed. And some of the new motions are just as ridiculous as the old ones. So the motion he did grant was to allow her to consult with her advisory council during breaks from the trial, including at lunchtime. Apparently, she had not been able to do that with the last trial. The state withdrew a motion having to do with 403B character evidence. And the prosecution also asked not to show Nicholas Balance's face. Now, Nicholas Balance is the FBI agent who testified in Lori's Idaho trial. and he was the expert who testified on all the cell phone data from the FBI. So to me, it's kind of weird that they're asking not to show his face in this trial, because he showed his face in the last one. It wasn't that he was kept out of court on the last one. So his face is out there and all over everywhere. And then she just filed a motion to suppress evidence of the Jeep Wrangler, and it was just filed. So we don't know anything about what that motion is and whether or not the judge is going to set a motion hearing once he's had the chance to review that. So we will close that out. So we don't really know. It was interesting that she wanted very much to keep her witnesses out or off the witness list and not tell anybody who she was calling, which is absurd. But she tried that in the prior trial too. She kept saying, well, I don't want to give away my whole case. And the judge really couldn't convince her that that's not the way that criminal trials work, that full disclosure by both sides is required. She wasn't having it. And as a result, she had several of her witnesses that were precluded from the last trial. That wasn't really because it really was because her motions and her witnesses and her discussion about what relevant information those witnesses had wasn't satisfactory to the judge and wasn't legally sufficient. So I don't think that the judge was off base by saying, if you want me to grant your motions, file motions that are legally sufficient and that have a basis in law. You know, there comes this time when being your own lawyer probably isn't the best idea. But she has been adamant at this point that nobody can represent her better than she can represent herself. So choices have consequences. And while I am hugely cognizant of everyone's due process rights and their absolute right to have their case heard and their rights protected. You know, you can only protect someone from themselves so long. And Lori seems intent on shooting herself in the foot over and over again. So we're going to have yet another trial where she's going to represent herself about the attempt on Brandon Boudreaux's life, and we'll see what happens. Brandon Boudreaux is expected to testify. At this point, we do not, nobody has Melanie Gibb, Zulema, or, well, I take that back. Nobody has Melanie Pulowski on the witness list. She's not on the state's witness list. Lori has put both Melanie Gibb and Zulema on the list, and on her list, and the judge said he was going to wait to see whether or not they had relevant information. So the judge didn't completely preclude calling them, but I'm sure that he will require her to make some proffers of what it is that they're going to testify to before he decides whether they have relevant information or not. So that is the Lori Vallow craziness for the week. The Menendez brothers had a hearing today, and the judge, actually, I think it was yesterday, and the judge resentenced them, which was a little bit surprising. Initially, prior to the last election cycle, so prior to last November, the Menendez family had been asking the district attorney and petitioning for the resentencing of the brothers, saying that they've been in jail 35 years, that they wanted the judge to consider resentencing them to a sentence. Over the 35 years, California law has changed, and so it would be possible for them to be resentenced to a sentence that would allow them parole. And their family, including the siblings of their parents, their aunts and uncles and cousins, have been petitioning quite heavily to get the district attorney and the court to resentence them, and the DA to agree to it. So the prior DA filed a motion asking the court to reconsider their sentences based on the changes in California law, and made an argument for that. He was he was defeated in the November election, and a new DA took his place. That DA immediately went back to the court and asked the court to withdraw their initial motion to resentence the Menendez. And the judge denied that motion and said, nope, you're stuck with it. You can argue against it in court, but you're stuck with going forward with having a hearing. There were a lot of different machinations going back and forth on whether or not to allow a risk assessment, a recent prison risk assessment to come in. The hearing wasn't televised, so we weren't privy to what was going on, but the judge did find that it was appropriate to resentence them and to sentence them to a sentence that would allow them parole. So as it stands right now, they have the judge resentenced them, and now they are free to apply to the parole board. They are eligible immediately for the parole board, the California Parole Board, to hear a request for parole. So that will now work through the ordinary channels, and that takes a while. It's not something that happens right away. So it could be weeks or even months in the future before they go before the California Parole Board and the parole board actually makes a decision. But they're definitely, there are no further roadblocks to them being eligible for parole, which I kind of think is the right choice. Both of them have been pretty much model prisoners since they were imprisoned, and I think they probably are entitled to just at least have the opportunity to present their case to the parole board. So we'll wait to see whether or not the parole board takes up their petition and whether they're granted parole. But that could be months in the future. And there's big news, believe it or not, in the Murdaugh case. If you remember, Alec Murdaugh was accused of murdering his wife and son to cover up his financial problems and the fact that he had been stealing from his law firm and his clients for years. And if you remember, at the last trial, the clerk of the court, Becky Hill, wrote a book, and there were some allegations that she had been involved in conversations with the jurors that could be taken as witness tampering. Well, today she was indicted on felony charges, including obstruction of justice and perjury, probably because of the testimony that she gave before the senior judge that came in to hear the case. She's accused of trying to influence jurors, and she's also accused of using the misuse of county funds. I guess the big question is how, if at all, will this impact Alec Murdoch? So far, the courts have said that Becky's behavior didn't directly impact the findings of the jury, but that could change as he goes through the appeals process. With her being indicted for misconduct, it does make you wonder. Certainly, they are going to make it an issue. So we'll wait to see what happens, what the impact of that might be on his appeals. And certainly, she was arrested and booked and read her indictment, and it appears that she's out on bond. So we'll wait to see what happens, but the plot thickens there in South Carolina. And then one other case before we get to the Karen Reed case, which I'm sure everyone is watching, is the God's Misfit case. This is Tiffany Adams, who is a grandmother. She is accused, along with 4 other people, of murdering her, the mother of her grandchildren, and the woman who was sent to supervised visitation. This is another toxic grandmother. So Tiffany Adams, the other people were Tad Cullum, who was her significant other, Tiffany's, a married couple, Cora and Cole Twombly, and Paul Geis. So Paul Geis and Cora Twombly have taken plea deals and testified at the preliminary hearings against Tiffany Adams and Tad Cullum and Cole Twombly, who didn't take a plea. Tad Cullum has filed a request to recuse the judge who has been assigned to this case, because at some point years ago, before he took the bench, while he was still a practicing attorney, he represented Tiffany Adams in a divorce. So Tad Cullum now claims that gives the judge a conflict. I don't believe it does. The judge didn't believe it does. And so, but Tad Cullum has filed an appeal to the judge's decision not to recuse himself. So he is now waiting for that appeal to wind its way through the appeals court. So he's kind of on hold. His case is sort of on hold while we wait for the Supreme Court or the appellate court to make a decision. In the meantime, Tiffany Adams and Cole Twombly are on for arraignment on July 30th. Different states do things differently. In this case, they had preliminary hearings at which Cora Twombly and Paul Grice both testified. Paul Grice very explicitly about his involvement and their involvement in the murder of these women. And now that the preliminary hearing finding, in most states, you either go to a grand jury or you have a preliminary hearing. So now in this preliminary, because the court found in the preliminary hearing that there was probable cause, fulfilling the same role as a grand jury would, now a post-preliminary hearing indictment has been issued and they have to be arraigned on it. So that is scheduled for July 30th. Now, the 2 that took plea deals, Paul Grice and Cora Twombly, are on for a date in November that they just list as further proceedings. Since they've entered into a plea deal, I'm sure that that probably is going to be the date for them to enter their guilty pleas and put their pleas on the record. So I suspect that they're going to go ahead in November and plead guilty, and then the judge will sentence them. Now, they may very well put off sentencing until after the trial of the other co-defendants. The judge could. The problem is that if you sentence them now and the others go to trial, the judge is a little bit hamstrung by what the co-defendants are sentenced to, because the judge can't sentence them in a way that makes it look like they got more strict or harsher sentences because they took the case to trial. Does that make sense? You cannot be penalized with a harsher sentence because you take your case to trial. So the judge may very well say, I'm going to withhold sentencing until after everyone's trials. It's very clunky because the other two can't go on to prison and get out of county jail until they're officially sentenced. So it's going to be clunky either way, but I wouldn't be surprised to see the judge say, I'm going to withhold sentencing until after everyone else is done. I don't know for sure whether Tiffany Adams and Cole Twombly there's too many moving parts in this case, have waived speedy trial. So we don't know for sure whether there's some pressure on to get these cases to trial. But we should know more on July 30th when they get arraigned, and hopefully they'll be actually setting some dates. Now, on to Karen Reed. Karen Reed retrial, or as some law tubers have called it, Karen Reed's re-persecution. Thank you, Jackie, for reminding everyone. Please like and subscribe. I appreciate you all being here. Please remember, give me a thumbs up. And if you are not a subscriber, please subscribe. Hit that notification bell so you'll get notifications when we do surprise lives, which we do occasionally, usually when a verdict comes in. So, I was thinking a lot. I've been thinking a lot about this case as it goes forward, and as I watch it, wondering whether the state is doing a better job of presenting their case this time. I think that Hank Brennan has been more focused than Adam Lally was. I think that there were many times that Lally was using the shotgun approach or the throw spaghetti at the wall and see what sticks approach. I think Hank Brennan has been more focused, but that may be his downfall as well. So we can talk some more about that. There was no court yesterday because Karen Reed was ill. Now, anybody who's been following this case knows that Karen Reed has had a lot of health problems, and her health can be fairly fragile. She has MS, and she's had a lot of surgeries. It came out during testimony last week in the text messages that she was sharing with Higgins that she'd had multiple surgeries because of cancer, what she termed colon cancer. So I don't, I know whatever is out there in the public, but I know that her health has always been pretty fragile. The other thing but she was back today, and court was in session today. So the other thing that Hank Brennan has been having to deal with is the fact that the lead trooper, the lead investigator on the case, Trooper Michael Proctor, was terminated as a state trooper because of his conduct on the Reed case. Both his bias and his inappropriate comments and his lack of investigation. So he was fired. His boss, who is Yuri Buchanan, who has been on the stand for the last few days and we're about to talk about, was penalized 5 vacation days because of his lack of supervision of Michael Proctor. And it appears that Lieutenant Tully, who was Buchanan's supervisor, has been in hot water as well. One of the defense attorneys attempted to get into that, and the judge headed him off. But I don't think that's going to stay secret for long. So 3 of the last trial days were with Yuri Buchanan. And it's clear that the state has put him in a very difficult position because he wasn't the lead investigator. He was supervising the lead investigator, but he is now having to come in and defend the investigation. He keeps going back to the investigation was conducted with integrity and honor, and Alan Jackson just took him apart about that based on Michael Proctor's own being fired for the consequences of his conduct on this case. So it's becoming more and more clear that the state is not calling as many witnesses as they did in the first trial. They are trying to avoid calling some of the more difficult witnesses like Brian Albert and Kevin Albert. Brian Albert was the owner of the home where the John O'Keefe was found. And Kevin Albert is his brother, who is a Canton police officer. Brian Albert is a Boston police officer. So lots of law enforcement connections. So Yuri Buchanan was on the stand for the better part of 3 days. And Alan Jackson, once again, did a really masterful cross-examination of him. And in the process, really calling into question the suitability or the appropriateness of the investigation and the fact that it was really shoddy. Now there is a case in Massachusetts that they're relying on that allows the defense to point out the deficiencies in a criminal investigation and to say that because of a deficient investigation, a third party, a known potential third party was ignored or overlooked. There were some motions filed that Hank Brennan is trying to keep head off the defense from offering that information. But certainly it has really been the drumbeat of every law of the defense with every law enforcement witness. As they have gone through the law enforcement witnesses, the defense's drumbeat has been, shouldn't you have done this? Shouldn't you have done that? Isn't it typical in an investigation? Now, one of the things that happened before trial was the defense wanted to call an expert who is a police investigator and an expert on police investigation techniques. And they wanted to call an expert to talk about what is and isn't a proper criminal investigation, particularly what is and isn't an appropriate murder investigation. And the state filed a motion in limine to keep that expert out, and the judge granted that motion. And in doing so, she said, I think that the jury is able to judge what's a good and a bad investigation without an expert. I'm not sure that that's true, but they are free to renew that motion, and I think we're going to see them renew that motion. I would not be surprised, because I think they're going to argue that the door has been opened by Uri Buchanan's comments and his testimony that the investigation was done with integrity and honor, and that it was done appropriately, and that they did all of the things that they were should have or could have done to investigate. So I wouldn't be surprised to see them renew that motion, saying that the state's opened the door to that expert coming in, and I think that would be a wise thing for them to do. Then, of course, there was no court yesterday, and then today we got several witnesses. We got Zachary Clark, who was Massachusetts State Patrol. Mostly what he did was photograph and document Karen's SUV. We also got Evan Brent. He came and documented the crime scene at 34 Fairview, and what was really interesting was he didn't come and document that scene until days later, after all the snow had nearly melted. And even at that, he was told to just take sort of big pictures of the property. So he didn't get in and focus in on the area where John's body was found. Nobody took the pictures of those things, and they certainly didn't take pictures of 47 pieces of red taillight. I think the defense has done a great job of pointing out, when they had Buchanan on the stand, they had him go through some of the bags with pieces of taillight in them. Some of them were as big as a dinner plate and red. And yet they weren't found in the snow until days and days later. So I think they've done a really good job of raising doubt about the investigation, and they've done a very good job of pointing out that there was a fairly wide lapse in time when Proctor had access to Karen Reed's car and had time to go out and drop a few bits of taillight around. So I think I think the defense is, in general, getting what they want out of these witnesses, and I think things are going pretty well for them. One of the things that I've seen some questions on is Hank Brennan's decision to play a bunch of excerpts, a bunch of clips of Karen Reed's media interviews. And for the most part, I have not really seen that those help the state that much. They, there have been a few of them that don't put Karen Reed in the best light, but they're more out there to attack her character than they are to actually have any kind of a factual basis. And I think it's unfortunate the judge has allowed them in, because they are her own statements, but I'm not sure that they have really done all that much to help the state. What we didn't see today, because the judge had ordered that the cameras be turned off for this portion, was that they brought in John's niece. Now, and in the last trial, they took testimony from both the niece and the nephew. And the intention was to bring them in to talk about what went on in John O'Keefe's household, and whether or not he and Karen Reed were arguing a lot, or whether or not there was fighting going on, or what. So for what it was worth, they only brought in the niece. They didn't bring in the nephew again. I am never a fan of bringing kids in to testify. And these kids have been so terribly traumatized. I mean, initially, John took over as their guardian because their mother and father both died. Their mother died of cancer, and their father had a massive heart attack and died 3 months later. And John stepped in as their guardian because he was their uncle, and there wasn't anyone else. So they've already been through a tremendous amount of trauma, and then they lost John. So um, I, I I suspect that there was a better way for them to get in that information, or did it really help them to say, well, Karen and John had a conflicted relationship? Karen's Karen's own text messages said that. I mean, she was texting with Brian Higgins, and they were kind of flirty texts, and she was talking about her relationship with John. She was talking about how conflicted they were about the way that they treated the children. John didn't like that she spoiled the kids. He was a kind of a tough taskmaster. He didn't like that the niece was somewhat close to Karen, and did girl stuff with her. And Karen was conflicted because she said she never really wanted children. And so she was thrust into this situation. She and John had dated when they were much younger, before John's sister died, and it didn't work out. And then they rekindled their relationship years later. And she was thrown into a situation where there were children. It was a family, and John was part of a package deal, and it led to conflict. John also may or may not have had an alcohol issue, and may or may not have had a bit of a roving eye. And those were things that caused conflict in their relationships, in their relationship. She was pretty transparent about those things in her text messages with Brian Higgins. So I'm not really sure that they needed to bring the children in order to point that out. And I think that it was difficult. I think that it may have backfired on them because the jury's going to be sympathetic to this child. So that I wasn't thrilled about that, because I don't believe that bringing children in is a good idea. The next person who was on the stand was Maureen Hartnett. She works for the Criminal Support Response Unit. This is the unit that actually should have come to 34 Fairview and done the initial evidence gathering, rather than the search and rescue unit. So she received some of the taillight pieces, and she also was responsible for going to the Sally Port and taking samples from Karen Reed's car, and finding glass on the bumper and a hair on the bumper. And Alessi Scissorhands, as some people call him, Alessi cross-examined her, and he is definitely their go-to when it comes to experts. One of the things he very quickly pointed out is that when that car was pulled into the Sally Port in Canton, it had traveled 30 minutes worth of 40 miles from Dighton, where Karen Reed was at her parents' house, to the Canton Sally Port. And he had a lot of really pointed questions about Was that hair stuck on with something? No, it was just free floating, and I took it off with tweezers. Was that piece of glass, very tiny pieces of glass, stuck to the bumper? No, it wasn't. It was just sitting there. So he made a lot of progress by saying, hang on, how do those things stay on the car bumper for 40 miles of driving? He also pointed out what appears to be a mistake. It appears that in a photograph where she says there's two pieces of glass, there's only one piece of glass, and it's actually a reflection off the bumper that makes it look like there are two little markers when there's only one. So she's not finished. They're not done with her cross-examination. And I will say that Alessi has been surgical, but he has not been bullyish to her. He's not. I will say that when Alan Jackson started cross-examining Buchanan, he definitely was being much more head-on and confrontational, and I think that was appropriate for Buchanan. Buchanan made some pretty broad statements that I think Alan Jackson did a good job of calling him out on. But I would say that I think Alessi is taking a little bit different tactic, because this person, this Marine Hartnett, she's just doing her job, and she doesn't know whether somebody walked over and sprinkled glass on the bumper or dropped a hair on the bumper. All she knows is what she collected at the scene. She also processed the red Solo cups and to test them for DNA, and she swabbed the car for DNA as well. So we're not done with her yet. And I expect that there's going to be some pretty pointed, but not eviscerating cross-examination. I think that Yuri Buchanan came off looking shifty and dishonest, and I think that Alan Jackson's cross was very effective. I think the next person we're going to see is probably going to be the accident reconstruction folks. Apparently, they're going to call Trooper Paul again, even though he is a terrible witness and a poor accident reconstructionist. I think that the Commonwealth has another accident reconstruction person they're going to call. I think I don't know whether the Commonwealth is going to call the medical examiner or not. If they don't, I'm sure the state will, because the medical examiner couldn't determine the cause of death. So those are some of the witnesses that we still have coming up. So I'm ready to take some questions. Please be patient with me because I'm doing my own modding tonight. Jen and her husband are moving to North Carolina, and they have been in California. So they're doing a cross-country drive with 3 dogs as they're making the move. And she wasn't sure whether she was going to be available and have Wi-Fi and all those things by the time the show started. I got a text from her that they were pushing on to try and make as much time as they can. And so I appreciate so much everything Jen does for the channel, and I'm just, everybody keep them in your prayers for safe travels, and I'm sure she'll be back with us next week. Hopefully a little bit more settled in, but we'll see. So they're quite excited about the move and looking forward to it. But please post questions, And I will start scrolling through just a little bit and see if I find your questions. So please just be patient with me as I am moving through these things. Jackie, woohoo, Karen Reed's trial is really something. Defense attorney Ajax, that's Alan Jackson, is doing fantastic. Yes. I think that any law student who is out there trying to learn trial practice, these are graduate level courses. Watching him in action as all of the defense attorneys is really a graduate level course on trial practice. They are pretty amazed. Rachel says, I'm amazed that Karen has been able to sit through 2 trials, and this is the first time she's been sick that we know of. Yeah, I agree. She's been taking her, I think they've been trying to take care of her as much as they can, and she's been staying strong. I'm impressed with her as well. Jackie says, biased Bev is so corrupt. I don't know about corrupt, but definitely biased. She has shown her bias on a number of occasions, and it just becomes more clear all the time. The idea that she brought in the doctor who has all the ER experience and has been and all the dog bite experience, and subjected her to a 2-day voir dire before she finally agreed to let in her testimony, and then wouldn't even give the defense a hearing on their motion to exclude this guy named Crosby, who nobody knows what his expertise is, but he's not a veterinarian, he's not a medical doctor. In the first trial, the judge kept the accident reconstructionists from commenting on the cause of John O'Keefe's injuries because they were not medical doctors. So now it appears she's going to allow the accident reconstructionist to opine. So really, really, her rulings have been pretty lopsided. Yeah, Liz, I think that if they had called in the CSI teams, they would have had to let more people in on what they were doing. I think that's a possibility. Liz says, I've decided that the whole bunch have alcohol problems. That is a true statement, sister. And I will say that it is not an unusual circumstance with police. They see and deal with a lot of awful, terrible things, and alcohol is one way that they deal with it. I think you see a much higher rate of alcoholism among first responders in general, and definitely in police. So it's not at all surprising. Unfortunate, and I know that there are many, many agencies who work very hard to help their officers with critical incident debriefs and trauma-informed debriefs and trauma-informed therapy and all of those sorts of things, so that they're not self-medicating. But, you know, it also is a network of not wanting to appear weak. So that's a problem as well. Liz says, I don't get how the tow truck driver wouldn't have been able to verify the tail light. He would have plugged into the car's system to have the lights working on the road. I think somebody else in the chat pointed out that they actually put that car on a trailer. One of the things they would not want to do would be to plug into the car, because that could potentially impact the infotainment center and some of the other black box sort of information. So I believe that it was put on a trailer, and then the tow truck driver drove it off the trailer and drove it into the Sally Port. So, but it moved around under its own steam, uh, to be sure that they weren't changing things. Um, let's see what else we have here. See what we have. Not a question, but thank you for the commentary on the Reed trial. I don't watch it. I come to you for a recap. Well, thanks. I'm not really giving as in-depth a recap as some of the law tubers are. So I know that the lawyer has been doing recaps. I think Gigi, who's not a law tuber, but Gigi at Pretty Lies and Alibis has been doing recaps. So I've been watching every day of the trial, but I probably have not been giving you the in-depth recaps that a lot of people have been. And I, it wasn't my intention to go back because we only do the show on Wednesdays. I kind of presume that if you're following a trial, you're getting your recaps at the end of each day. And so I don't want to plow the same ground that you're getting from everybody else. So, but stick in with us, Teresa, because we are going to continue to do some thumbnail recaps of what's going on in the trial, and certainly commenting on any of the legal issues, because I think that's one of the reasons y'all come to see me. So sorry about that. I am trying to pull up my own opinion. I thought Brennan was doing a better job than Lally until Trooper B got on the stand. Rachel, I thought he had some fits and starts, and I thought that there were places where he was doing a better job than Lally did. And he has had Lally actually doing some of the questioning, and we actually heard from Sarah McLaughlin today. We rarely hear much from her at the state's council table, but we did hear a little bit from her. I think that there were definitely some places where Hank Brennan was doing a better job, but he's got to work with what he's got, and the whole Trooper Proctor and Buchanan, that is just a nasty mess, and I don't know that anybody could deal well with that. And I I think he's doing the best he can with what he's got. So, um, does Melanice have immunity in this trial like last trial? Hi, Carol. We have never known for sure whether Melanie Boudreau Pulowski, that's the person we call Melanice, um, had immunity or not. We've never really known if anybody had immunity other than Zulema, because we learned about that during Lori's trial. The other Melanies were not really sure whether there was actual immunity agreements on the table. So we do know that Melanie was supposed to testify at Lori's trial, and then admitted that she had been watching Brandon Boudreau's earlier testimony in the trial, and the state decided not to call her rather than to put her before the judge and let the judge disqualify her. So they called her husband Ian Pulowski, but not her. So we don't really know whether she has immunity or not, and what role she may have in this trial. Now, remember that she was one of the only people who had Brandon Boudreaux's new address. When they divorced, they sold the family home, and Brandon had moved into a rental home with the children. He was required, because he had the children living with him, he was required to give Melanie that address. Melanie was the only person that knew where his new address, that had any contact with Alex Cox or even knew him. So we'll wait to see whether or not they implicate her in this conspiracy. And it may be that they've offered her something for that. We don't know. I asked because of her giving out Brandon's address. Yeah, we don't know for sure. But I suppose we'll see. If it were going to happen, it would happen in this trial. If she were going to be brought in as a precipient witness and brought in to testify and offered immunity, it would be in this case. So we'll wait to see what she has to do. Do you think either side will call Higgins, Proctor, other big names that were in the first trial? So I think that the state is not going to call Brian Albert or or Kevin Albert. I think they got in what they needed to through Jen McCabe. I don't know. I think that the defense is sort of happy with the way that the text messages came in through Buchanan. So they were able to get Buchanan to read all of the text messages between Karen and Higgins, Brian Higgins, all the flirty texts and that whole text thread. Buchanan had to read it, and so, or Buchanan, I guess is the way they pronounce it. So he read them all, and I think the defense runs the risk of, if they bring Brian Higgins in, he could look a little sympathetic. He could put on, I was kind of the guy that was led on, and Karen was just using me to make John jealous. Buchanan said that in his testimony, that he believed that was her motivation, but it would hit different if they put Brian Higgins on. So I think that the defense may be satisfied that they got what they needed without having to put Higgins on and run the risk of him looking like a big old floppy teddy bear who was just used, because he's led around by his nose. I don't think. I think that the Commonwealth is going to try and avoid putting Proctor on. I don't know that they're going to be able to do it, but I guarantee you that the defense is going to put him on. And more than likely, they're going to ask the court to treat him as a hostile witness, which means they can ask him leading questions. So essentially, in direct, you question your witness, but you have to ask direct, sort of open-ended questions. On cross-examination, you can really get into drilling down and, making them answer those yes or no questions. So if they ask the court and she grants their request to treat him as a hostile witness, they then could really get into a lot of more cross-examining kind of questions. So Carol has a question. Carol, did I get it? Did I find it? let's see here what we've got from Susie. My nephew is a tow truck driver and he has to walk around and document any damage before hooking up. But if law enforcement drove it on the trailer, I can see how he wouldn't do that. Yeah, I mean, if law enforcement are the people saying we need you to move this car and you're gonna drive it onto the trailer and drive it off, and it is evidence in a crime, I'm sure that law enforcement was telling him the less you handle this car, the better. We don't want you to, uh, we don't want to run any risk of evidence being contaminated. Yeah. So, um, let me see here. Still trying to catch up on a few questions here. Okay. Carol got her question answered. Thank you. So, I'm going to continue to follow the Reed case. There are a few cases coming up, but nothing immediate. Next month, of course, the end of June, we have Crystal Rogers. That is Brooks Hauk and Joseph Larson will be on trial. And so I expect we're going to see some pretrial motions in that case. Crystal Rogers' case is a case where her body has never been found. And very suspiciously, her father was shot and killed while he was out searching a year later while he was out searching for her body. So that's a very convoluted case. We also, we had Larry Millette coming up in July. That case has now been moved. Maya was his wife, and that is another nobody case. Her body's never been found. That case has been moved to January of 2026. So James Craig is coming up in July. He is the dentist who has also been accused of trying to get inmates in the jail to kill witnesses, including deputies. And of course, the end of July starts Brian Kohberger. We're going to continue to see lots of motions in the Kohberger case, and they're continuing to come out. There was a Dateline episode recently that came out with some information that there's been a lot of consternation about, that it may have been information that was leaked. It definitely is information that the public had not been privy to before. And so that is a little concerning, but because there are gag orders in place. So some of that information may very well have been leaked by one side or the other, or someone closer to the case. Lindsay Shiver is still on for the end of July in the Bahamas. Now, that case absolutely will not be live streamed, and we don't have a lot of information about scheduling and whether motions are being heard or any of those things, because the Bahamas has a very different system than we do. And so I am going to be gone the second week in June, working on a new project that I'm excited about, and so I'm going to be doing some traveling for that. And when I have a little more information, or when I'm ready to let everybody know, I will. I'm going to put this up. Thank you, Carol. I hope everyone had a good Mother's Day. I know that for some folks, Mother's Day is hard. I saw a post or a YouTube post from Colby Ryan saying Mother's Day's hard. I mean, he has 3 little kids and I'm sure wants to honor his wife on Mother's Day. However, Mother's Day, I'm sure, is hard, and there are lots of folks out there um, for whom Mother's Day is difficult for any number of reasons. So I hope if Mother's Day is a hard day for you, that you were kind to yourself. And for those who had a joyous day, I'm glad. I sure did. It was delightful to have my daughter and son-in-law close by. I am so reveling in the luxury of having them close by and being able to have them drop in on me or me drop in on them or so I had a lovely day. We went out to a very nice brunch with the whole family, including my son-in-law and his parents. We're really blessed by the fact that over the years that our kids have been together, our families have become close, and I consider them some of our closest friends. So it was delightful that they were here. They recently bought a condo in Central Oregon, so they could come up more often. And so I'm sure we're going to see more of them. And so they were here. We had a lovely brunch. I spent a couple of hours with my daughter at her house, and we just hung out and played Rummy Cube and had a great afternoon. And so I'm so grateful. I'm grateful to be closer to her and grateful that her life is perking along and that she's doing well. So. Um, so I hope you all had a wonderful Mother's Day. These beautiful flowers behind me were my Mother's Day bouquet from my daughter. And I've had to sort of keep the lilies separate because I have cats and they're not healthy for cats. They can be deadly, but I'm enjoying them because they perfume my office, and I'll be sad to see them go. I have a question here. Do you think Lori is going to throw Melanie under the bus in the upcoming trial? Maybe. Um, I don't know. She hasn't been quick to throw anybody else under the bus. She has not been quick um, to let anybody put the blame on Chad or Alex. So, I mean, if I was going to guess, I would think no, that she won't throw Melanie under the bus. Um, I could be wrong, but so far she has declined to do that. So. Well, my friends, I think we have exhausted questions, and I think we've exhausted the things that we all wanted to talk about. So I want to say thanks for being here. Thanks for your patience with me being my own moderator tonight. Please keep Jen and her husband in your prayers as they are driving cross country for safety, and that the move goes smoothly for them. And I just want to thank all of you for being here and joining me on Wednesdays. I know that there are many things you could be doing with your Wednesday night, and yet you're here. So thanks for that. Oh, I did want to say that I got to do a book event last night. It was great fun, and I was at my alma mater, Oregon State University, where I got my um, master's in creative writing, and they invited me to come back and do a little book talk, and it was delightful. We had a nice crowd, and I also found out that they're asking me, the local community college has asked me to teach some community ed classes on true crime writing. So I'm excited about doing that in November. So, and I love to teach, so it'll be fun. So thank you all for being here tonight, and I will see you next week. Let's see, Jackie says, I'm going to have to play this Rummy Cube game. Oh, it's so much fun. It's like a combination of dominoes and gin rummy, and it is great fun, and I have enjoyed it. My son-in-law's family introduced us to it, and we play a lot, and it's a great game. It's one that my mom has a little trouble with games that she needs to like learn the rules, but she knows how to play rummy, and the rules are sort of the same, and so it's a game she enjoys playing too. So when she's with us, we play. So she likes any kind of cards. So, well, I'm going to say good night to you all. Have a great evening. I'll see you next week. I doubt that we're going to have any sort of excitement in between now and then in terms of verdicts or those sorts of things. Karen Reed case is expected to go 6 to 8 weeks, and we don't start the Brandon Boudreaux trial until the end of May. So, but I will see you next week on Wednesday, and I'm sure Jen will be back with us. So thanks for joining us, and good night.